Good afternoon. Hope all of you are having a fun show. So, this is the second year we're doing this one. It's always well attended, usually a little bit later because we're one of the few that serve alcohol as we talk. So we're going to be talking to you about things you're going to need a drink for. So before we get started, let me introduce our illustrious panel. My far left is Angelo Amador. He's the Executive Director of the Restaurant Law Center, an incorporated public policy law firm associated with and founded by the association. The Law Center represents the industry before federal and state courts and regulatory agencies. He is also Senior Vice President for Legal Advocacy and Regulatory Counsel at the National Restaurant Association. The industry is the nation's second largest private employer, comprised of over 1 million restaurant and food service outlets, employing about 10% of the U.S. workforce. Angelo is a graduate of the Robert H. Smith School of Business at the University of Maryland. He has attained a Master of Arts at the International Transactions from George Mason University and graduated cum laude from George Mason University with a degree of law and a distinction from his Master's of Laws in International Comparative Law from Georgetown. He's been an adjunct professor at law at the George Mason University School of Law and also served on the faculty of the Virginia Beach Law Enforcement Training Academy. To my immediate left is Alicia Voltmer. Alicia, I love her bio because she's always quick and to the point. Board certified labor and employment shareholder at Greenberg Traurig in Dallas. She's an SMU undergrad and law school, represents employers in all aspects of labor and employment with a focus on hospitality. She likes to climb mountains. Ask her later about Kilimanjaro, that's I guess in 3 weeks. She's a published author of The Rise of Lady Justice, a supernatural legal thriller. If you haven't read it, it's wonderful. My name is John Gessner. I'm a partner at Carrington Coleman, based here in Dallas, and serve as co-chair of the hospitality industry group there. I've practiced hospitality law for 38 years. I'm a past chairman of the Texas Restaurant Association, currently serve as the PAC chair for the Restaurant Association, and on the executive committee of the TRA. And I've just been appointed to the Tabc Public Safety Advisory Committee. So this is your group. The drinks that are going to be passed around are going to be made by Alfredo Huerte from Mi Cocina. Alfredo. And Alfredo, if we can get you a mic, could you tell us a little bit about our first drink?
Yeah, we're gonna be featuring the Desert Sotol. It's made from a wild sotol plant. It's spicy, aromatic, earthy, piney. It's going to be delicious.
So the way our format is I start talking and he starts distributing drinks to make my my presentation better. And then afterwards we keep going from there. So feel free as we start talking to go ahead and start distributing drinks among the crowd. Great. So what are we going to talk about? Well, with me, when we're talking about Texas and what you need to be afraid of and what you need a drink for, that's probably dealing with alcohol law in Texas, primarily the TABC. And if for those of you who were here about an hour ago and heard the TABC representatives, they have a lot of things that they're doing right now, and I'm just going to point out a few of them that I think are things that everyone who serves alcohol in Texas should know. The first one, and they talked about a little bit, is called AIMS. It's the Alcoholic Industry Management System, and this is the future, I guess, with TABC regulation. It's designed to transform all of the paper filings that we've been doing for literally decades and convert it to an electronic system. It started out a little rocky. Rocky meaning it basically didn't work for the first couple of months, and then after that it worked sporadically. They've worked on it quite a bit. They have really feel good about where they're going, but it's still not there yet. But why is it important? Well, it's important because if you're doing a new license, the only choice you have right now is to go through AIMS. So you have to do their electronic. If you're doing a renewal, that's one of the few choices you have to do it. I will tell you, having done both the renewals and the actual initial applications, renewals are much easier, but the application is there. So let me talk to you about a couple of things that you need to know about relating to AIMS and how to utilize it. First of all, and this is really important, and I don't understand why it's this way. It doesn't work with most of your servers. It works with Google Chrome or Microsoft Edge. It does not work with Safari on your iPhone. It does not work with Internet Explorer. Really important because you put a lot of information in and it simply won't hold it, if you can even access it. So you have to go upgrade to Google Chrome or use Microsoft Edge. It's designed to complete licensing and renewal of licenses, file excise tax reports, and other communications to and from the TABC. So in the future, instead of getting these little postcards, these letters, or emails from the TABC, it's highly likely you're going to get something through Ames, which is why you need to go on there. When you get on Ames, when you set up, the first thing you have to do is you have to create an account and you have to link your licenses to that account. Why is that important? Because they don't know who you are until they do it. And that's not a process of simply clicking a button. Linking it requires verification from them and it coming back to you. So if your renewal is due tomorrow and you haven't gotten registered for Ames, you're not going to make your renewal. So it's important to know this is something you need to do in advance. And you wouldn't know that by going on it, but I'm telling you, if you don't set up in advance, give yourself a couple of weeks to make sure everything's good before you start inputting your information. Another thing that's really important is if you are it is set up for a one-person ownership system, which most restaurants don't have. And most restaurant groups have one or more people working on their permits. So if you've got an attorney, you need to register him on your account, and that's also going to take a few days, so he can go back and forth on that. If you have one of the licensing services, the same way. And right now, getting someone registered takes a little longer. So I would give yourself plenty of advance notice on getting that. If you have somebody who inputs your excise tax information, they also have to be on there. It's designed to have separate credentials for each person you're bringing on, so that's important to know. If you're applying for subordinate permits or licenses, that's a very good use of Ames. Now, it's also something, they haven't worked out all the bugs, but it's actually a lot closer than it was. Why is that important? Well, for instance, if you're trying to do alcohol to go or alcohol delivery, you have to have a food and beverage certificate. A food and beverage certificate is not automatically given to you when you get like your mixed beverage permit. So you have to apply for it separately. Now, you can apply for it all at once at the very beginning, or you can apply for it later on. My suggestion to you is if you're setting up a new license and you think it's even possible that you might do any type of delivery or alcohol to go ahead and pay the little bit extra to set up the food and beverage there. Because what happens is it all gets reviewed one time and they don't have to come back on it. And they do give precedence to new license applications at the TABC because they're trying to bring down their time period. I think they said earlier today that it was 30 days or so to get it approved. As early as 6 months ago, that was 90 days. So they're working really hard, but by doing it, they're giving preference to the major new applications, and your application for a supplemental permit is probably going to come second. One of the things it's great on is you no longer have to wait in the mail and check, where's my TABC permit? Where's my renewal? Once it's issued on the Ames. You can print it off, have it in your window that day. So it's important to know that. The other issue, they want to be able to provide alerts. The TABC has improved their communication system. I don't know if you listen to Jared Staples here. He's been a godsend as a public information officer for the TABC. But this is the way they're going to try to communicate with us. So at some point, they want us going through their system and doing that. Okay, let's change from Ames and talk about safe harbor provisions. I know most people know what a safe harbor provision is, but Texas law has a little bit of a quirk that says that you can protect yourself from administrative actions if you meet certain criteria. An administrative action is typically an action brought by the TABC to enforce some sort of violation regarding your license. And usually the penalties for that are either suspension or revocation of your license or fines. So an administrative action is not something you simply look at. That's something you need help on. And I would suggest to you probably need legal help on that. There's some things you can manipulate through the TAB system yourself. Administrative actions are not that. They will have an attorney on the other side, and they will not take pity on you if you do not. So how do we get a safe harbor, and how do we restrain from administrative actions? Number one, and this is something most people don't know, first of all, the violation cannot occur where the person selling is an owner or an officer of the actual permittee. So if you set it up so that it's, XYZ LLC, and you're the manager of XYZ LLC, and you serve drinks, there is no safe harbor. My suggestion to anybody is that, they say, when you start serving alcohol or you open a restaurant, what's the first person you hire? It needs to be bartender. It needs to be a bartender that's somebody who's TABC certified and somebody who is not you or not an officer of you. Likewise, if you decide to give promotions to your key employees, make sure they are operational titles and not corporate titles. Don't make somebody a vice president of the company, because that could be an issue if that person's behind the bar or serving. So if you're in your restaurant and everything's undone and you've got 50 people waiting in there and you're trying to get stuff out of the kitchen, out of the bar, go help in the kitchen if you're the owner, not the bar. The second thing is all persons engaged in the sale, service, or delivery of alcohol must be TABC certified within 30 days of hire. So when you hire somebody, you have 30 days to get them licensed. That 30-day grace period does not apply when your license expires. When your license expires, they expect you to get it done immediately, if not, and you can apply earlier. So don't say, okay, well, I got a 30-day grace period after your license expires. That is not the case. Some people thought that, some people at the TABC thought that, but it's not the case. There are programs you can utilize that will keep up with the TABC certifications for your employees. I know there's some software programs that scheduling programs that won't allow someone to be scheduled for a shift if their TABC certification is not current. That's something I recommend highly to you, because sometimes it's difficult to keep up with paperwork on 50 servers, some of whom only work twice a week. One of the things that when you're getting TABC certification, it has to be everyone who is involved in the sale, service, or delivery of alcohol. So if you have a busboy that's delivering alcohol, that person needs to be TABC certified. The other person that needs to be TABC certified is the manager. Any managers on shift need to be TABC certified because they're interested in the sale, delivery, or service of alcohol. You have to post written policies, TABC policies like responsible alcohol service, and you can't do anything to discourage those employees from following it. If you have responsible alcohol policies that say you can only serve 4 drinks, and you're telling your servers, nah, go ahead and serve them 5 or 6, you've just violated your own alcohol policies and may have made yourself unavailable to this defense. You cannot have 3 or more violations in a 12-month period, and that's not in a fiscal year. That's a 12-month period. So if you have you have a violation today, you've got 12 months from today to not have more than 2 more. Let's see. I think at this point, how's the drinks, by the way?
Good.
And I got a couple more things to say. One final thing I want to talk about is breach of peace reports. Breach of peace reports, if an incident happens in your restaurant, you have to file a breach of peace report. And there's 2 types of breach reports. The first one is a 24-hour report. If someone is shot, stabbed, serious bodily injury, or someone has been killed from some other purpose on your premises, you have 24 hours to report it to the TABC. You can report it through Ames, you can send it through an email, you can show up at the TABC location, or you can through the app. If there is another situation, it's called the 5-day notice. If law enforcement or emergency medical technicians respond to your location, you have to file a TABC breach report. If there's a disturbance by someone who causes bodily injury to another, threatens someone with a weapon, discharges a firearm on premises, or destroys property if reported to law enforcement, you must file a breach in 5 days. And just so you know, when someone's threatening someone with a restaurant, if you've got a bunch of people with open carry who are carrying guns in your restaurant, that threat could happen very quickly. If you have a security officer who is cleaning his gun and fires it on the location, even in the back room, that has to be reported to the TABC. Failure to file a breach of peace is an administrative violation. They can go after your license for it. There is some changes coming to the TABC breach of peace. The only thing it's going to do is expand your premises to include any area under your control, such as a patio, and it also will apply to more licenses going forward. I expect that rule to be final in probably a few months. One last thing about TABC. So 2 years ago, when we had the pandemic and we started doing emergency enforcement, they pulled the TABC enforcement officers off of a lot of investigative duties and put them on enforcing those rules. The problem is that meant that a lot of investigations weren't finalized when they were started in a normal fashion. So you now have a lot of administrative violations being filed based on issues that happened 2 years ago. So I've got at least 6 or 7 right now that all date to 2020. You have to take those seriously, and you have to be careful about it, because a lot of times your employees, I don't know about you, but 100% turnover for a lot of restaurants make it difficult to track down those employees. So be aware, if the TABC comes into your office, they may be talking about something in 2020 or 2021 or something that happened last week. So, guys, that's all I have about TABC. I think it's time for a new drink. What do you think, Alfredo?
The next drink's going to be a Patron Margarita with Patron, fresh lime juice, agave, and Grand Marnier.
Great. So at this point, it's all yours, Alicia.
Hi, everyone. Thank you for coming this afternoon. Can everybody hear me all right? Great. I've got 3 topics I want to cover. The first one is unions. The second one is sex harassment. And the third one is the 80-20 new tip credit rule. So let's start with unions. Unionizing is on the rise in the restaurant industry. We are seeing it in Wisconsin, New York, California, Oregon. And most of you are probably, your eyes are glazed over already, saying those are all blue states, we don't care. They're not coming here. Well, guess what? They're here. We already have 4 Starbucks unionized in Texas. We have 2 in Austin, 2 in San Antonio. And I will tell you that unionizing campaigns and unions are a lot like ant colonies. Once you see one ant or one union organizer, you probably already lost the battle. You've already got the ant colony underneath your porch or in your bathroom, and you've already got the union in your shop. And why do you care about this? Well, because unions increase your costs, and you're at a time right now where that's probably the last thing that you need. Also, I will tell you, most of you don't know this, that union rules apply to non-union employers. Let me repeat that. If you are an employer and you have no union in Texas, the rules that apply to unionized employees also apply to you. So if you did not know that, you do need to know that, because they're very specific about things you can and cannot do. For example, can you have a policy that says you can't record anything in the workplace? Yes, no? Anybody know the answer? You better be careful, because there are rules about that. You can have a policy that says they can't record things like trade secrets, can't make recordings in a bathroom, but if they pull out a recorder and want to record a meeting with HR, they're allowed to do that. Or things like what they can post on social media. Rules apply to those folks as well. So you need to be aware that unions are out there and understand how they work and what you need to do if you have a union organizing campaign. Because once you get a campaign going, there are certain rules where employers are not allowed to make threats, interrogate, make promises, or surveil employees. So if you have a manager and you have a union campaign and your manager says, hey, you better not vote for that union or I'm going to fire you, that's illegal right there. Can't do it. So you need to make sure that you know what's going on in the industry, you watch, because across the country, it's not just Starbucks being organized. We've got Voodoo Donuts, we've got burger joints, we've got fast casual, we got all kinds of restaurants being unionized right now. So if you think that you're immune from it, you are not. Second topic, 80-20 tip credit rule. Everybody familiar with this one? Does anybody have tipped employees? A couple folks? All right. This is a fun one because this rule changed and I think a lot of folks don't understand how. We now have 3 buckets of work for tipped employees. You have tip work, you have work that supports tip work, and you have non-tip work. So if I'm a server, tip producing work would be bringing a tray or bringing an item to my customer. Tip supporting work would be something like clearing the table between the meals, or bringing another napkin, or refilling a water glass, something like that. Non-tip producing work would be work like cleaning a bathroom. Can't take a tip credit for that. Here's where the rule changed. If you have an employee who takes the tip credit and they work 20% or more of their tip credit time on the second bucket, which is the supporting work, the rolling silverware, those kinds of things, not direct customer service, or in a shift, 30 minutes or more, they are doing the second bucket, which is that supporting work, we used to call it side work, then you don't get to take the tip credit. Think about this. You have a server. They're in a lull in the middle of the day. They're sitting there waiting for a customer. They wait more than 30 minutes. Guess what? 30 minutes, you don't get to take the tip credit for that time. So you have to start planning on how you are going to organize your servers, how you're going to manage them, how your operations are going to go. Because if you have people with a lot of downtime, you're going to lose the tip credit. Or if you have people who do a lot of side work, 20% or more of their tipped work is side work, they're going to lose the tip credit. You're going to lose the tip credit for that work. So your takeaway here is you need to understand this new rule, and you need to be able to plan for it. Because what happens if you mess up? Y'all know this. Department of Labor gets a phone call, XYZ restaurant, they're not complying. Then what happens? They come, they audit, and it's not just this employee, but it's all these employees. They're not being paid correctly. Then you get your class action lawsuit, and then what happens? You got to take your checkbook out because you're probably going to end up paying some money. So prepare for this, be prepared, know what you need to do. Final topic, sex harassment, our favorite, right? Yeah. All right, so that law changed in Texas as well. It used to be 15 or more employees. If you had 15 or more, Henry, I see you laughing. If you had 15 or more employees, the sex harassment law applied to you. Well, that changed. Now, if you have 1 or more employees, that law applies to you in Texas. So you may say to yourself, I've got a small shop, I got less than 15 folks. Still applies. What else changed? All right, well, the definition changed. It's a lot broader. So it's any physical or non-physical act that is sexual act that is intimidating or threatening. So it's a broader definition where you can be tagged for sex harassment. And managers can now be individually liable. Guess what? Guess what state that's like? Oh, come on. California. Just like California. We're just like California now, where managers can be individually sued. And guess what? We all know managers aren't going to have a deep pocket, right? So who are they going to sue? You own a restaurant? They're going to sue you, jointly and severally. So they'll sue you, they'll sue your manager, and then they're going to look to you for the payment. Because you got the money, right? You're shaking your head. No, I don't know if I have the money. What else has changed? All right, final thing here. You cannot arbitrate sex harassment claims anymore. Y'all hear me okay over there? All right, so if you have an arbitration agreement and it has every kind of claim imaginable, it's going to be arbitrated. You cannot force an employee to arbitrate a sex harassment claim anymore. Okay? So what do? Do you take it out of your agreement? Do you have a new agreement? Do you have a jury trial waiver? What do? Well, you better do something, because if you try to force someone to do it, it's not going to be valid. Now, if they choose to arbitrate, that's fine, but you cannot make them do it. And you need to look at your forms and see what you have in them so you know if you've got one that has the old language or not. And this applies, by the way, this applies to arbitration agreements that you may have in the past that someone signed. If you have an arbitration currently pending, it's not going to apply. You're under the old rule. But if tomorrow someone comes up and says, I have a sex harassment claim, you cannot force them to arbitrate. Big change. Questions on that? Nope. All right, I pass the baton.
Okay. So let's talk about our third drink.
All right, we're featuring a mojito made with Bacardi rum, fresh mint, lime juice, and a little bit of sugar.
Nice. This is my first time giving a presentation accompanied by alcohol, so I hope it's more interesting than the previous one, especially because I'm going to expand on what my colleagues just said. And I would say something on arbitration before I talk more about the Restaurant Law Center, what we do, and 80/20, and what we, together with the Texas Restaurant Association, are trying to do to stop the regulation. One of the things with arbitration and sexual harassment, you're going to see a lot more claims in court where they're going to claim sexual harassment. The reason for that is if everything else is covered by an arbitration agreement, you can try to get back in court by starting with sexual harassment and then putting everything else that would otherwise go into arbitration. So for the Restaurant Law Center, I think it's important to go back and see what's in the name, because we have been asking states, and there will be an announcement later, to create their own law center. And we're called the Restaurant Law Center. If you look at the retailers, they have their own. It's called the Retail Litigation Center. If you look at the chamber, they have their own. It's called the Chamber Litigation Center, and so on and so forth. And the Restaurant Association decided we wanted to go further. We wanted to create a law center, which means that in addition to doing what I'm going to be talking about and what most people know us for, and what we are quoted in the newspaper, which is litigation, is this kind of thing, giving, and by the way, Greenberg is a member, a law firm partner of the Restaurant Law Center. They give educational. We have an educational webinar every month. We do webinars for the states, and we have a conference, which we hope both will join in October, where all these law firms come, and that they provide for the members of the National Restaurant Association, which is kind of like the parent company. Going back to 80/20, and I asked for a drink. I don't know if it is divided 80/20 between Bacardi and everything else, but it is, the rule itself goes a lot further. It's called the dual jobs final rule. It used to be called 80/20, but it's much more than that. As Alison explained, that 30 minutes, it's key, because before you were looking at occupation. If you look at the final rule in 2020, it said, look, if you're a waiter and you're doing the duties of a waiter, and we know what the duties are. You can go to ONET, which is a website from the Department of Labor. You look at occupation and you look for waiter, it will tell you what the duties are. And it will tell you that some of those duties are wiping tables. It is there. It will tell you that cutting lemons is part of the duties of a bartender. It is there. So we said, well, as long as you're doing that, that's fine. What this regulation does, and it never came into effect. It was finalized in 2020. It was supposed to come into effect in 2021. The Biden administration came in and froze it and then did away with it because they came up with what they think is a better and improved 80/20 rule. But what they did is they divided in tasks. So now it's one of the reasons I left law firm practice. I didn't want to continue dividing my day in 6 minutes increments, but now you waiters have to. Because if you waiter wipe the table while somebody's there, that's tip producing work. If the people that was at that table just left 2 minutes later, 30 seconds later, and he's wiping, that is no longer tip producing work. That's supporting work. So you have to account it separately. So how are you going to account for all of that? Every time they do something different, you have to punch in and out. It's really impossible. So what we were saying in court when we sued and we tried to stop this rule is you cannot account for that unless you're coming in and out every 30 seconds. Not only that, wiping a table while after somebody left is not tip producing work for a waiter, but if a busboy wipes that same table, that is tip producing work for him. And then the question comes, what happens if it is in a law and the person is working on napkins, rolling silverware, that is work that assisted producing. So if you don't want to deal with that and you say don't do anything, just stand there and wait, well, the Department of Labor is now thinking that you just have to pay that a minimum wage. So you don't have any control over that. So the Texas Restaurant Association and the Restaurant Law Center filed a lawsuit here in Texas. First, we tried to stop it, get an injunction. It was not granted, and we appealed to the Fifth Circuit. So we're now on appeal, trying to stave the regulation. We had some very good developments. Number one, the Texas Attorney General, together with the Louisiana Attorney General and the Mississippi Attorney General, those are the ones that make the Fifth Circuit, together with like 8 other states, file a brief in the Fifth Circuit saying the restaurants are right, this doesn't make any sense. So that is going on the Fifth Circuit. We also still have the lawsuit in the district court, and now we have a decision from the Supreme Court that says you cannot make up your own law. This decision that you may have been reading about, the EPA and environmental, it goes way beyond that. It says if it's not in the law, you cannot make it up by just passing a regulation and saying, well, we couldn't get it through the legislature, so we're going to just pass a regulation. And I challenge anyone to find anywhere in the law where it comes up with this 20%. Where is this 20% coming from? Nowhere. It's coming up from thin air. Somebody came up, made it up years ago, and they've been evolving it. And now, because the court said, well, this is not even in a regulation, well, it's now a regulation. So we're going to be filing on Monday, reminding the district court, look, this decision just came from the Supreme Court. Maybe you should read it, and maybe you should look at how it applies to our case. So that's something, again, we are very fortunate to have a great partner in the Texas Restaurant Association, because when you're filing in state court, you need the support of your state affiliate, and they have always been on board with us. So that's kind of what we do. That's what we're doing with 80/20 and a number of other laws. We like challenging in Texas. They talk about forum shopping. We do it. We love the judges in Texas. However, the district court judge doesn't seem to be a fan of ours. But you know, we'll see what the Fifth Circuit has to say. So with that, I'll stop right now. What else do we have?
So I've been asked to read a breaking announcement, and that is the TRA seeks to provide you with the best resources and support possible to run your business. We are proud to announce the relaunch of the Texas Restaurant Law Center. Myself, Carrington Coleman, Alicia with Greenberg Traurig, and Monty Ramirez. Monty, are you here? Monty, will be the 3 attorneys that are initially staffing the Texas Restaurant Law Center. So what that provides is that any member of the association can go on the website, put in some information regarding what type of dispute it is, so it routes it to the proper lawyer. And each of us have agreed that we're going to give a free 15-minute consultation relating to an issue of your choice. Now, that doesn't mean you talk for 15 minutes, you hang up, you call back, and another 15. No, it does. It's 1 15 minute. So that's going to be going forward. We anticipate that that's going to be rolling out. We're proud to continue supporting TRA's members and give you access to employment, immigration, alcohol, and business law services. So that just came out. So I think that ties very well with what Angelo was talking about.
And that is, you know, you may think, well, 15 minutes, right? What does that get me? We have that at the national level. And I tell you, we got big brands, little brands, you know, everybody calling for this kind of advice. If nothing else, it will tell you if you have a case. And sometimes you don't want to hear the news. Sometimes it's you don't have a good defense, you better settle. That alone is very valuable. You have a problem with regulation, you know, you have a problem with a number of issues. These lawyers, you know, from immigration, labor, and just business in general, the experience I've had, and I'm sure because I have dealt with them as well, the state level will be the same, is very valuable to know where you're standing in basic else. And then, you know, if you want to take it further, you know, that's for you, but it's kind of like a good reality check in 15 minutes. And again, I would not, I cannot underscore the value of, you know, presentations like this, but the value of content that I'm sure that will be provided for the rest, for the Texas Restaurant Association. So I think that's, when they told me about it, I said that's great, because that also gives us at the national level another partner in the states where a lot of, with the dysfunction that you may or may not have noticed from Washington, D.C., a lot of the things are being pushed at the state level. So a lot of the work that I do nowadays is actually more state-based than nationally based.
Great.
So, can I?
Sure.
We've covered a lot of topics in brief. Does anyone have any questions about TABC, about 80/20, harassment, unions, anything?
That's it. They're bringing a microphone to you.
It's coming.
Are they attempting to enforce the 80-20 at all at this point, or have y'all seen anything like that?
I haven't seen any enforcement actions yet, but they're coming because
So-
that's revenue.
So I would say two things, right? There's two kinds of enforcement. There's private actions, so those are your employees. Those can come at any moment, right? They can go talk to an attorney. They're tracking the case. They're tracking the case to see. The federal government, they're also going to wait to see how the litigation goes, because one of the arguments, when you go and try to get an injunction, you got to say that, the sky is falling and this is going to be horrendous. And the federal government came in and said, this is no big deal. Nothing is really happening. The restaurants are just screaming that the sky is falling, but it's really not. They're waiting for the litigation to be over now. Since there's not an injunction, whatever is happening now, if they file in December of this year, they're still going to look at your actions throughout the year. So it is very difficult because it is almost impossible to comply, right? We, in federal court, we had a restaurant in Texas, owns 5 restaurants, and is public, is a filing, and they said it will cost about $1 million to comply. And the judge laughed it off and said, well, why, for $1 million, why didn't you hire an employee? And we laughed back and said, Your Honor, if we take your analysis, you would have to hire 1 employee per restaurant, that's 5, and then you will have to hire 2 because it's while the restaurant is open, so that's 10. You do the math, that's already 6 digits, that's a lot of money. So the impact would be there. How do you keep track? If you look at the way they're dividing, there are certain things that you can do, maybe hire somebody to do that side work, doing all these other things. But when you look at the inconsistencies within the law, the regulation itself, it's almost impossible to comply. So again, I'm hopeful that we're successful, but yeah, you're already under the threat of potential litigation.
And it's not just litigation, it's when the Department of Justice or Department of Labor shows up at your door and they want to audit. And most employers don't know. You can say no, let me call my attorney, and that's the first thing you should say is, great, here, give me 5 minutes, you get the attorney on the phone, the attorney calls the investigator and says, gosh, we're super busy, come back next week, we'll be ready for you. That's the right answer, so you can be prepared for that audit.
Yeah, the magic words, let me call my attorney, help in a lot of situations.
Any other
Yes,
questions?
sir.
Got a question for you, John. So we were talking about delivery, TABC Safe Harbor.
Yes.
If we've outsourced that, Grubhub, DoorDash, things like that, where does that stop?
Oh, see, and this is, I help work on this law. So whenever you put together a law, sometimes there's some things you see on the top and there's some things you see underneath. What we were able to do is liability for delivery of alcohol services goes to the deliverer once it leaves the restaurant. So if there's service to an intoxicated person or service to a minor, then the delivery person is on the hook for it, not the restaurant.
Get the microphone. Then the microphone is coming,
Yeah,
so they can hear you. Maybe you can repeat it.
I'm sorry, not to beat a dead horse here, but like the user agreement between like a DoorDash or something like that, if there's a transfer of liability in that agreement, do you still have the TABC responsibility shift to the outsourced delivery?
So the way most of those are written, it's what when you issue a statement like that you're going to ensure basically that you pick up the problem. If there's a problem, it's transferred. In this particular case, that would work for civil liability, but it doesn't work for criminal liability.
Okay.
So you can't indemnify someone for their own criminal activities. So if they're selling
Thank you.
somebody, okay.
Appreciate it.
I would add that the law in Texas is one that we have shared with other states as well, because we do like the liability shifting after he walks out the door. So
And it's good to
job,
know
good job.
that, with the safe harbor rule, it is something that the TABC has come up as not a carrot, but not a stick, but a carrot. It's what they do is they basically say, look, we're going to encourage you to promote training in your restaurant. We're going to encourage you to get your people TABC certified. We're going to encourage you to invoke responsible alcohol services. And if you do that and something happens that's not your fault, then we're not going to hold you specifically 100% liable for that if you've done all the right things. So it's one of those things. It's a very rare thing that we find in the law where there's an incentive rather than a disincentive or a punishment. So this is where something where the TABC has been very good, and like Angelo said, a lot of states have sought to emulate it because it works. It works in our group and it works with others. Other questions? Monty, could you let them know, aren't you speaking tomorrow?
About immigration, and unfortunately, we don't have any great news for you all on that front, but we do have some helpful hints that we'll talk about. It's hard to hire right now. We need to hire, make sure that we hire folks that have documents. We're not document experts. We're going to walk you through how to do that tomorrow. We're also going to cover the Hall of Shame, documents that you should not accept. 2 people in 1 photo. Folks that appear on their ID with the glamour shot photo like this. You know, as long as you avoid hiring folks with those types of documents, also misspellings on the documents. Texas is not spelled with a J, it's with an X. If you can avoid hiring folks with those types of documents, you're going to be all right, and you should hire them. You need to make sure the I-9 is completed. We're going to talk about that tomorrow on the main stage at 10:45.
Great.
Thank you.
Thank you, Monty. Any other questions? At this time, I'd like to really thank Alfredo for putting together these drinks. I think he's in the back cleaning up, but if we have people here. Thank you, Alfredo.
Thank you, Alfredo.
And if there's leftovers, you can come get it. No, right? Guys, thank you very much. We first started talking about doing this. It's about serving drinks. This is way better than my first idea of I was just going to pass a bottle and pass it down. So guys, thanks a lot. Appreciate it. Hope you enjoy the rest of the show. Thank you.
Thank you.